If you want to say it loud, 'cause someone out there listening. If you're gonna think it, think out loud, 'cause you don't know what you're missing till you let them all in. Oh, oh, oh. Tell them what it's all about. Oh, oh, oh.
You're listening to the Divorce Registry podcast, talking about real people, real issues, and real solutions.
I'm Jonathan Fogel, a family law attorney.
And I'm Amanda Johnson, a family law paralegal. This is the Divorce Registry podcast, where we provide informative, entertaining, and invaluable insights into all aspects of family law. You can reach us at thedivorceregistry@gmail.com, and be sure to follow us on Facebook.
Amanda and I are partners at work and in life. We are both divorced, and we have 5 kids between the two of us. Some call it chaos. We just call it family.
We call it chaos too.
Yeah, you're right.
The signs say you'll be coming up roses soon. It all comes back to you. It all comes back to you.
Hi, Jonathan.
Hello, Amanda. I'm sorry, I was just singing our song.
You were singing.
I was.
Do you want to sing for us now?
No, I definitely do not.
Okay.
It'll be coming up roses soon. Don't forget.
Oh, well, welcome to the Divorce Registry podcast. I wanted to just touch base on
I'm gonna take
one
my
of
glasses
our
off.
one of our previous episodes regarding self-care
Yeah.
and how we talked about things we do for ourselves, and I just want to point out and say how great you were in your show at Stevie Ray's.
Oh, thank you.
Because you got chosen to host for
Yeah.
3 shows.
Yes.
And so you ran those shows, and it was really fun to see you up there doing something so different than being an attorney.
Yeah, and for those who don't know, Stevie Ray's is an improv troupe that I've been in now for a couple years, and I got tapped to come up and host 3 of the shows, and it was great. It was so much fun. I had such a great time, and I thought the audience was really fun, and I was beyond nervous. I was super scared to do it, but to step out and do something like that, and then 2 hours of improv with the rest of the troupe was so fun.
My kids loved it. And if we're plugging some Stevie Ray's here, but like they love going there and watching that, and watching the interaction on stage is so fun. But you did great.
Oh, thank you. That's very nice.
Yeah.
Thank you. I'm glad that you enjoyed it. I'm glad your kids had. I could hear your daughter laughing from way in the back of the house. So
Way too much, probably.
No, that was good. That was good. I always love that. It kind of brings more energy if people are actually laughing. That helps.
Well, and when you're in a relationship with somebody and you want to give and take between each other, and you want to teach each other, right? And you want to learn from each other. And I think that's something you've done for me in going off and doing that in your life, that extra outlet that you have created
My
for yourself.
extracurricular activities.
Yes. A positive extracurricular activity.
I think they're all positive.
And it has, has brought me back to my roots of wanting to get on stage again. And although I will not say what it is, because that would absolutely be horrible to put out there, I will be auditioning next week for something, which, again, I'm so looking forward to just putting myself out there and doing that again, even though I don't expect it all to get in. It's like, if I can make it through the audition, I'll be good.
All right, I'm going to tell you what you tell me. Stop with the negative talk, all right? And just go in and have a great time doing it, and put yourself out there and let what happens happen. And I have to tell you, this is something we've been talking about for a long time. I think since we even started dating, and I knew that you used to do a lot of theater. I'm like, you need to go out and audition. And you were in those commercials, which I loved. And so I'm super excited for you and very proud of you that you are putting yourself out there.
Thank you.
So it's very exciting.
It is.
Yeah.
And scary all at the same time.
Well, a lot of things are scary, but that's how we grow, is
I know.
facing those fears and trying to figure out how we get past them.
Yeah.
So
Okay, so today this is part 2.
Part 2.
So episode 8. We started at episode 7 last week, discussing the divorce process, more of a settlement track of divorce process, right? Beginning until reaching an agreement after mediation.
Yep.
Today we're going to talk more about the divorce process, picking up maybe around mediation, and then when that doesn't work, where we go from there.
Absolutely. And so I don't want to get into all the stuff about meeting with the attorney and a retainer agreement and summons petition. Go back, listen to episode 7. We talk about all those terms. We talk about that process. I want to start with what happens when things break down. What happens in the divorce process when you've gone through all of that, you've done all the informal discovery, you've gone to mediation, and you can't reach an agreement for whatever reason. We don't have to get into why, but let's assume that's where we're at and what happens in the timeline after that.
Right.
And we're going to post all this on our Facebook page, so check that out. We'll have kind of the timeline there for people to look at. Because I think it's important for people that are going through this, as my job and your job as a paralegal, is to educate people as well. It's not just about, okay, let's just get them through the process. The way that people make, I think, really good choices is when they have knowledge, right? I mean, knowledge is power, no question. The more they know about the process and how things are going to go and what the next step is, they can make better informed decisions.
Yeah. And we have certain clients, I think, who want more of that, to know what's going on. We've come across clients who really just want us to take it they don't have, a foot really. They just want it dealt with.
Right.
We have to kind of pull them in. I know.
And right. And
yes.
I don't like that. I don't like when they go, okay, you just handle it.
I know.
Because I don't think that's my job. My job isn't to make decisions for them. My job isn't to just handle it. My job is to make sure that they know what's going on and then handle it based on their input and their participation in the process. And it is hard. It is hard to be a participant in that process sometimes because it is very overwhelming. And our job, I think, as attorneys is to make it less overwhelming by providing the information that we're providing. So let's start with, okay, we go to mediation, it doesn't work, we can't reach an agreement. What happens next? So in most cases, what would happen next is there would be some sort of what they call a temporary hearing. Okay, what that means is that you go back to the judge at that point and you tell the judge, we couldn't work this out. We need your help. We need you to make a decision about certain things. So at a temporary hearing, the judge has the authority now to make a decision on things like temporary child support. And when I use the word temporary, I use that because what that means is the judge is making a decision on what's going to happen from now until there's a final divorce decree, right? What I look at that is, I always kind of analogize it to, we are going to put everybody on the same playing field, right? This person may make more money, but the judge is going to order that there be some support. So now both people can come to this on level playing ground, right? Or playing field, right? So the judge has the ability to make a decision about support, both child support and spousal support or alimony or maintenance, depending on what you call it in your particular state. The judge has authority to make a decision about who's going to stay in the house. So one person can be removed from the house, even against their own choice. The judge can also make a decision on temporary parenting time, temporary custody,
release of funds if they need to be released from a
temporary
bank account.
attorney's fees, things like that. Absolutely. So that would be the next step. And to prepare for that, there's a lot that goes into that. You meet with your attorney. They draft what's called affidavits. And again, pleadings or a motion for temporary relief. A motion for temporary relief means simply that you are making a motion, you are asking the court to give you certain relief. And then the other side gets to respond to that motion and say, either, no, I don't agree with what they're asking, give us this instead. Or they can say, yeah, I'll agree with this, but not this. Or I agree with some of it, but let's change it a little bit. So both parties get to submit that stuff to the court. Some jurisdictions do it differently for temporary hearings. Here in Minnesota, there's no testimony at temporary hearings. Some states do allow actual testimony at a hearing, a temporary hearing. A lot of states like Minnesota will just do it by what I call it's affidavit hearings, meaning that you get people to write affidavits, including yourself. And an affidavit is simply just a more formal letter to the court, essentially. It's, what is my story? What is the history of this case? And what am I asking for? And here is why.
And I think it's important for clients to know that although, no, you are not paying a judge when you go to court to sit in for their time, you pay your attorneys for drafting everything, and you can draft a lot of it yourself, but then we have to take it and put it into the form we need to. And there also are filing fees with the court.
Yep.
For every there's an initial filing fee just to get divorced, and it's different everywhere. Then there are motion fees. So if you're going to bring a motion here in Minnesota, it's $100.
You have to pay a filing fee to do that.
When you file your motion, every single motion, and if you file a responsive motion to their motion, you're paying $100.
Right. Yep. Yeah, and that's why in this litigation track that we're talking about here in this episode is one of the reasons why costs just continue to go up. Now, mediation is expensive as well. You're paying the mediator, you're paying your attorneys, but if you settle at the mediation, the fees, you still have some fees to draft a judgment and decree. I don't said that a little bit weird, so it didn't sound right to me, but I didn't say it twice on purpose. But you have to pay to do that. But to go down the litigation track becomes much more expensive.
This temporary hearing, you see the fees go up quite quickly within a week period of time because you're filing those papers. If you are the person requesting relief from the court, 14 days ahead of time. And so we're working on those pretty quickly to try to get those in.
Absolutely. So then the next thing is once you go to the judge, Ian's going to have to fix a lot of this stuff. I swear to God, I feel like I'm like...
Do you need some water?
I don't know. I need something. Maybe I'm just too excited today about this stuff. You go to the judge for a temporary hearing, and then the judge issues an order. Now, different jurisdictions have different timelines of how long the judge, sometimes it's 60 days they have to issue an order, sometimes 90 days. What I would tell people is don't expect to walk into the courtroom on a temporary hearing and have a decision at that day. It could be months before you have a decision from the judge. So be aware of that and talk to your attorney about how long judges usually take. A lot of judges take longer time than other judges.
Yeah, and in the summers, you kind of notice things can take longer because
Right.
I think a lot of judges are taking their vacations.
Right, or if it's getting around the holidays,
Yeah.
judges take holidays too.
Yeah.
So be aware of that. It's not you walk into court and you get an order right away. And also be aware that you don't always get everything you ask for from a judge, right? You're going in, you're putting in your request. The judge may see things a little bit differently.
I don't know of anybody that I could think of that got every single thing they asked for, ever.
Yep.
I don't think that happens.
Well, and even if they do, even if people get everything they asked for, I had to pay a lot of money to get what I asked for, and that's frustrating.
Yeah.
And I want to emphasize, too, it's written down here, is that your attorneys should always be trying to still negotiate in the background, right? Even if you're going to court, there is always opportunities to reach agreements, to negotiate. I can't tell you how many cases I've had where we have shown up to a temporary hearing and reached an agreement right there on the steps of the courthouse, right? Or before we walk into the courtroom, it's, hey, let's talk about this real quick. Because it's always better, I think, to keep that control for the clients.
Well, and I don't know about temporary hearings, but do the judges usually even then ask you guys to take a minute and talk before?
Sometimes, yeah. A lot of times the judges will start out, and I think the really good judges will do this. They'll say, are there any agreements before we start? Mm-hmm. And they'll ask that because, like I said in episode 7, they don't want to make the decision. They would rather have you make the decision. And some judges will say, do the attorneys think they're close? Or a lot of times the judges will pull the attorneys into chambers before a temporary hearing and talk to us about that. And I'm glad you brought that up, because that's one of the things that I think clients get very frustrated about is the attorneys go back in chambers, talk to a judge, and we come back and, okay, here's what the judge is going to do. And they're like, wait a minute, I spent all this money to have a judge make a decision. I wanted to hear what they have to say. I wanted to get the judge, and you guys went back there and just made a decision. That is not what happens. We don't go back there and just make a decision. What we do is go back because the judge sometimes knows that if he can talk to the attorneys directly and we can be more candid when we're not on the record, the judge may get some insight into the case and may actually help facilitate that settlement. Now, the judges can't make pre-decisions before hearing all the evidence, but some judges will say, hey, look, this is what I'm hearing. This is what I think could happen. This is the upside. This is the downside of that. Do you now want to go back and talk to your clients to see if maybe we can reach some agreements?
Another frustrating thing that I've heard you come back and say is that you'll go into court and realize that the judge didn't even have the opportunity to review everything, which was submitted 14-10, 5 days prior to this hearing.
Yep.
And I think the clients are going, wait a minute, we spent all that time.
And the
it
judge
does,
never
it's not
looked
to
at
say
it.
they're not going to look at it before they issue an order, but their calendars are busy and sometimes they don't get to it. And I think that gets frustrating.
Yeah, and I know our goal is to have one of our future episodes, I'd really love to have a judge come in and talk about that. What is their caseload? What are they up against? How much, time do they really have to look at every single case? Probably not very much. And I think the judges take their jobs very seriously, but because of the backlog in the system, they don't have time to read everything and digest it and analyze it before we walk into court. Sometimes they do that afterward, which is why they have such a long time to make a decision. They have to go back and reread it and look at it again and get brought up to speed. And that's frustrating too. If a judge doesn't make a decision for 60, 90 days after the hearing, the clients think, well, how did they ever remember any of this? How did they even know what we talked about? And legitimately, those are appropriate things to be frustrated
Sure.
about.
And I think that's where their clerks come in a lot too. Their clerks are there listening and helping out. But
So let's move on to the timeline. We got a little far afield, but this is good stuff. I hope that it's helpful for people that are listening to understand where this process goes and why it's so difficult. So once there's a temporary hearing and maybe a temporary order that's issued by the judge, the next thing that usually happens is discovery. Now, in episode 7, we talked about informal discovery, which is done by a letter and just niceties, right? Yeah. Oh, please give me this. Okay, thank you so much, right? This is more formal discovery.
This is a demand.
Yes, this
no,
is
I'm just kidding. Make it law and order.
Well, it technically is a formal request for discovery, and there are rules that require certain things to be provided. There's things called interrogatories, which is, again, a fancy term for I'm asking you a question, you need to answer it. And then there is request for production of documents, which is exactly what it means. It's a request for the other person to provide you specific documents. And attorneys will draft these, and a good attorney will not just use boilerplate questions and boilerplate requests, but will cater it to your particular case, right? If there's a business, we want specific things about the business. If someone has a lot of debt or if someone is asking for spousal support, we may ask questions more about their income and their ability to earn income and what their monthly expenses are. So each formal discovery request should be tailored to that particular case. And those are sent out. And then the other side has a specific amount of days to answer those.
Usually 30.
Usually 30 days is what the rules are. We send those out. They have 30 days to provide us answers to the questions and the documents that we have requested. The thing about doing it formally is if the person doesn't answer in that amount of time, then the person that made those requests has the opportunity now to go to the court and ask for the other person to be found in contempt or to be found in violation of the requests and ask for them to pay their attorney's fees because they are delaying the process. And I would tell people that if you get those requests, you need to make a full disclosure of everything that's being asked of you. Because if you don't, again, you could be hit with sanctions or attorney's fees for not following the rules. Another thing that can be used in discovery is a request for admissions. We don't see it a lot in family law, but I've used it before. You're asking for someone to admit or deny certain facts. So those, again, are ones where we want to tailor those to the specific facts of this case. And again, there's timeline for those to be answered. And in those, if they're not answered within that timeline, the rules say that they are deemed to be admitted, right? So that's an important tool to use. The other thing that we use are subpoenas. We have the power to subpoena documents. I've had cases where we've had to subpoena phone records. We've had to subpoena medical records. We've had to subpoena employment records, tax records. I mean, you name it. We have the ability to subpoena those if the other person isn't providing that information. Right. Problem is, like we talked about before, all of these things cost money.
And take time.
Another type of discovery is if people can't resolve their issues with respect to custody and parenting time, is that there may be a custody evaluation. And we're going to have a custody evaluator come in on a future episode and talk about what a custody evaluation is and how long it takes and how much it costs. On this, I just want to say that is a tool that can be used if people cannot agree. And they usually take 3 to 6 months, and they are very expensive.
Yeah.
And it can be very intrusive, not only in your life, but in your kids' lives. But that is another tool that would have to be used if we can't agree, because the judges need someone to come in as a third party and tell them what's the best thing for the kids, what are the recommendations under the statute. The next thing is, if there's emergency things that need to be dealt with, maybe there's emergency hearings or phone calls with the court to deal with maybe someone, there's a case of domestic abuse, you have to have someone removed from the home immediately, or there's other emergency issues, you can request formal conferences with the court or an emergency hearing.
Or somebody's not doing something that was ordered at a temporary hearing. A lot of times the judges now want you to set a call with them to discuss it before they're going to set another contempt motion or a follow-up.
That's right. And contempt essentially is someone's not following the order.
Right.
That's what contempt is.
Right.
The next thing that happens in these cases that are more the traditional litigation is the court would set up what's called a pretrial. Okay, now different jurisdictions call it different things. Here we call it a pretrial conference. What that means is I always tell people a pretrial conference is basically the last-ditch effort for the court to give people the opportunity to resolve the case before it goes to trial, which is why it's called a pre-trial, right? Like pre-boarding doesn't make any sense because you can't, there's not pre-boarding. There's a joke out there.
Way too much about this.
But a pre-trial means it happens before the trial. It's an opportunity for the parties and the attorneys to go to court, and the judge basically says, okay, what's the problem? Why isn't this being settled? Mm-hmm. What needs to be done? And is there anything that I can do as the judge to help get a resolution? Mm-hmm. Some judges, again, are better at pretrials than others. Some judges, you never even see the judge at a pretrial, you even talk to the judge. You go there, and if you don't have an agreement, they go, okay, here's the trial date, come back for trial. Some judges will be more actively involved. I've had judges that say, plan on being here at least 3 hours if you come for a pretrial, because we're going to hammer this out and figure out how to get it done. Mm-hmm. So those pretrials are taken very seriously. And at the pretrial, it's basically an attempt to settle. You outline the issues for the judge, and then what the judge expects is if we can't get it resolved, you got to know basically what are the issues that are going to be identified for trial, how long the trial is going to take, possibly how many witnesses there's going to be called, and then the judge will issue what's called a trial order. Right. And you want to talk about the trial order and what that looks like?
Well, again, the trial order is going to outline when the trial's set for, how many days, what else is it? The deadlines for witness lists. So the witness lists you have to submit and have to say the name of the witness, who they are in relation to the client, and what they're going to be testifying about.
And if there's experts, you have to have expert disclosure.
Yes,
experts
like have to be listed on there as well. Usually there's a deadline specific for expert reports, such as a custody evaluator or a financial person who did something. They also have exhibit exchange deadline. Usually the court does not want the actual exhibits before the trial because they're so large and they don't want to look at them, but they do want to see the exhibit list of what each side is presenting.
Right. And then there's an opportunity to object to those exhibits. So usually that trial order says within, for example, 2 weeks before trial, you have to exchange exhibit lists and witness lists. 1 week before trial, you have to submit to the court any objections that you may have to the exhibits or the witness lists. And then the other side maybe has an opportunity to respond to those objections. And then what happens is then you go to the court for the trial and you have a trial. And trials can be, well, I shouldn't say can be. Trials are extremely exhausting. They're emotional. It's very difficult. You have to get up on the witness stand and testify. You can't submit affidavits for a trial. You have to have live testimony. There are rules of evidence that apply. People talk about hearsay or irrelevance and all these different objections to testimony. All of those things are dealt with at trial. And what I tell people is trials are not like you see on TV or the movies. It is not some spectacle where It's super exciting. It is.
It's like hurry up and wait.
Right. It is a monotonous process to get the evidence in, to make sure the judge hears everything, that you tell your story. But it's not a fluid story because there's objections, there's recesses.
There's witnesses taken out of order, people
That's right.
jumping in and, testifying.
And it can be a very long process. And at the end of the trial, just like a temporary hearing, the judge doesn't get up there at the end of the trial and go, okay, I've made my decision. Here's what we're going to do. After the trial, there's usually post-trial submissions, whereas each attorney is allowed to submit a proposed order to the judge based on the evidence that was heard. It's, well, we think it should go this way. And the other side, of course, has a 180-degree different view of everything. That's why you're in trial. And you submit those to the judge. And then the judge, again, has 60, 90 days, whatever it might be, to issue a final judgment and decree or a final decision on all of the issues that were pending at trial. And I would tell people, I've had cases where they've settled after trial, where people have done all the trial stuff. We've gone through a whole trial, and I get a call from the other attorney, and it's, hey, you know what? Based on everything that came in, let's sit down and see if we can't, come to an agreement. And we've done that before. So there's never the only time that you can't reach an agreement is after the judge signs it, right? Once the judge signs it, that's what you get. Yeah. Now, it doesn't mean you can't change that on your own, but up until then, you can reach your own decisions and make your own agreements. And then after the trial, when the judge issues that final decision, someone's going to be unhappy.
Yeah.
I mean, I'll be honest. Both people are unhappy a lot of times. Yeah. One person's unhappy. And then you risk the idea of appeal.
Yeah.
Right? I mean,
it's a whole nother process.
Yeah. I mean, there are statistics out there, and I don't want to quote all of them, but that basically when people reach agreements on their own, the likelihood of them coming back to court or appealing or having a disagreement later on is significantly less because they've bought into that agreement, right? They have reached that agreement on their own. Like, think of it, right? If you and I reach an agreement here on something, on what we're going to do for lunch, we're going to go there, right? But if you say, here's why I want to go, I may be like, well, no, I don't want to go there. I'd rather go somewhere else, and I'm going to be disappointed, right? So you amplify that by kids and money and future support and all of those things. If a judge is forcing that decision down someone's throat, it's unlikely that they're going to like it, right? And so then you face the possibility of one person appealing it to the higher court to try to overturn it. And then there's, again, you're multiplying the cost and the expense of this process exponentially when it starts to be appealed.
And not to mention what it does emotionally to everybody.
Absolutely. The cost isn't just financial. It is certainly emotional. And those are the type of cases where we see people keep coming back to us years down the road, that now this has come up. And they never learn those tools of being able to sit down and work with the other person because they'd rather have a judge do it. They say they don't rather have a judge do it, but that's what ends up happening, is that a judge has to make those decisions. So that's the process on the litigation track. Be sure to go back to listen to episode 7 because this gives us, that will put it in context and the difference between these two tracks, whether it's a settlement track or a litigation track. And, look, I'll say this again. I've said it before. I beat people over the head with this. If you're going to litigate and you're going to have a judge make a decision, you are giving up 3 things. You're giving up time, you're giving up money, and most importantly, you're giving up control. And you want to avoid that if you can and keep those 3 things to yourself. Yeah. Right? Yeah. The time, the money, and control over your own life.
Yeah.
So anything else you want to add about this timeline?
No, just that people need to ask questions along the way when they're in this process with their attorney, and they need to know that they have options at every step. You do have control at a lot of times on which way you want this to go. So.
And if you don't understand something as a client, ask your attorney. If they're throwing around acronyms that you don't understand or they're throwing around terminology that you don't understand, ask. The attorney. If the attorney's offended by you asking, get another attorney, okay? Because that's their job, is to educate you and to help you understand this process and not just push you through the process like another client and then get someone else in the door.
Right.
So, and if you have questions, you can send them to thedivorceregistry@gmail.com, and we would be happy to answer those questions. Thank you all for listening.
Nice job.
We're done with episode 8. All right. Thanks a lot, Amanda.
Thanks, Jonathan.
The information in this podcast was for general purposes only. The information provided was not legal advice or a legal opinion. You should seek the advice of legal counsel of your own choice before acting upon any information from this podcast. Contacting us by phone or any other means does not establish an attorney-client relationship.